When you talk about the view of international law, humanitarian law from the bench, you have to keep in mind that that view is very different from the view of, say, an ICRC delegate in the field, a military lawyer advising a commander, a soldier following legal advice. Courts are not generally proactive. We deal with the cases that parties bring to us, not the cases that we would select if we were going out to find what mattered most. Now that's particularly true of the International Court of Justice, because we can only deal with a case if either states parties who have so accepted the jurisdiction of the court send that case to us, or if the UN General Assembly or one of a number of other bodies asks us to give an advisory opinion. The second difference, which is also very important, is our jurisdiction depends, in a contentious case, a case between states, depends on both of those states having consented at some stage. So very often the issues over which we have jurisdiction do not cover the whole field of the difference between those states. If you take the case of Bosnia and Serbia and the later case of Croatia against Serbia, it's clear that the parties there would have liked to talk about a whole range of issues of international humanitarian law, but the court only had jurisdiction under the Genocide Convention, and therefore the only issue we could rule on was whether or not there had been genocide. Court work is very fact-specific. One of my colleagues used to have a wonderful cartoon on his wall of an American attorney standing there and saying to the judge, "Your Honour, could we, for a moment, forget about the facts?" You can never forget about the facts. A case is all about its facts. It's shaped by the facts. And therefore, any ruling of law that we give is going to be dependent upon the evidence that has been put before us. And in a court like the International Court of Justice, we are dependent, as far as evidence is concerned, on what the parties put before us. We have no independent ability to go out and make fact-finding, and I don't think it would be right for judges to start researching on the internet the facts of a conflict. Generally speaking, the role of a court is to look and see whether what happened in the past is a violation of humanitarian law, and if so, who is responsible for that. And we do that in immense detail. And one of the things that I think you have to bear in mind is that we can spend weeks discussing a decision that is made in minutes or even seconds. During the Kosovo conflict in 1999, one of the NATO aircraft fired a missile at a bridge, which was a legitimate target in the circumstances. But the pilot fired just as a train started to cross the bridge. He hit the bridge, destroyed the train, and it was one of the worst instances of loss of life in the whole conflict. That decision to fire the missile would have been taken in less time than I have just taken to set out the facts in the most summary form. And I sometimes feel a little uneasy that it's too simple for a judge to forget the pressure under which decisions of that kind have to be made.